In this video, I'm going to discuss about law relating to agency, which is an important area with regard to commercial law. So we'll move on to the next slide to see the topics which will be covered under this lesson. First, I will give you all a basic introduction about what is meant by agency and its legal implications. Then I will discuss the main methods of creating agency. After that, I will discuss about the duties of the agents and the principals. And finally, I will briefly explain the methods of terminating an agency. Basically, law of agency deals with the legal relationship between the principal and the agent in an agency relationship. Through agency, the principal authorizes his agent to act on his behalf and also to enter into legal relationships such as contracts with third parties. Therefore, the agent is a representative who creates or affects legal relationships between the principal and third parties, and also the rights and liabilities arising out of such contracts will be acquired by the principal and not the agent. So basically, for legal purposes, the acts of an agent are considered as the acts of the principal. In an agency, the principal's legal position towards third parties is affected by the agent's conduct and also by the agency itself. Therefore, it is clear that an agency could have legal implications on three main parties. They are the principal, agent, and also the third parties with whom the agent enters into legal relationships. Now let's look at the methods in which an agency can be created. In this presentation, I am going to discuss about agency by agreement, agency by necessity, agency by ratification, and agency by estoppel. Now let's look at how an agency can be created by agreement. This could be done either by express agreement or implied agreement. When it comes to by express agreement, the principal expressly appoints an agent to perform a particular task on his behalf, and once the agent accepts such appointment, an agency will be created between them. This appointment may be made in writing or verbally, and in certain situations, the law or statutory provisions may require such appointment to be made in the written form. This gives an actual authority to the agent. And also, an agency can be created from the conduct of the parties. This is known as agency created by implied agreement, and here the facts and circumstances imply that an agency has been created. In this category, the agent receives an implied authority and not an actual authority. Now let's look at what is meant by agency by necessity. This is a concept which was developed by the English law, and according to this, in urgent or emergency situations, a person acquires a presumed authority to act as an agent without any prior authorization by the principal. Such agency comes into play in situations where the agent is unable to communicate with the principal. However, here the agent has a duty to act in good faith and in the best interest of the concerned parties, and also the acts of the agent must be commercially necessary. Under this category, the agent is given a necessary authority. Now let's look at what is meant by agency by ratification. Here, the agency is created by the principal confirming a previous act done by the agent which was unauthorized at the time of performing it, and such act should have been done by the agent on behalf of the principal. Therefore, the agency is created retrospectively, and the relationship between the principal and the agent is created by ratifying such previous act. Here, the agent gets a subsequent authority. And here are some essential requirements of agency by ratification. The agent must have acted expressly on behalf of the principal. At the time of performing the particular act, the principal must have been in existence either as a natural person or a juristic person. The principal must have the capacity to do the particular act which was done by the agent. The ratification must be based on full knowledge of the material facts of the particular act. The act must be ratified within a reasonable time and the entire act has to be ratified. The last method I am going to discuss about is agency by estoppel. According to this, if the principal by words or conduct represents to a third party that some other person is his agent, the principal cannot later deny that agency if the third parties have relied on such representation he made. Here, the principal will be bound by the acts of such agent and also he is stopped or prevented from denying the representation he previously made. Under this category, the agent gets an apparent or ostensible authority. In this slide, I have mentioned the main requirements for agency by estoppel. There should be an expressed or implied representation made by a principal. Such representation must be based on facts, and the representation should indicate that such person is authorized to act as an agent. The representation must be made to a third party and the third party must have relied on that representation. And lastly, the position of the third party may be altered due to such representation. Look at the duties of the agents and principals in an agency relationship. The duties of the agents could be determined according to the nature of the agency and also the terms of the agreement between the principal and the agent. Here are some important duties of the agent. The agent must perform the contract or particular task he has undertaken to perform, and in doing so he must obey and follow the instructions given by the principal. And also the agent has a duty to exercise reasonable diligence, due care and skill in performing the particular act. The agent must act personally without delegating his duties to others, and also the agent must at all times act in the interest of the principal. The agent's interest must not contradict or conflict with the principal's interest, and he must disclose all the material circumstances that may affect the principal's interest. Also, the agent must not make secret profits or commissions while performing the assigned task, and he is under a duty of confidentiality. When it comes to an agency relationship, not only the agents but also the principals have certain duties. The principal has a duty to provide adequate remuneration to the agent as agreed between them, and he should indemnify the agent for any monetary losses or certain liabilities incurred by him while performing tasks on behalf of the principal. Finally, let's look at how an agency can be terminated. There are two main ways, that is by the operation of law or by an agreement between the parties. Under the first category, that is by the operation of law, an agency can be terminated as a result of death or mental incapacity of either the principal or agent, and also when the subject matter of the particular contract or agreement becomes illegal or frustrated. Under the second category, that is by an agreement between the parties, an agency can be terminated as a result of mutual agreement between the parties and also once the agency is completed by the agent as a result of performing the assigned task. So thank you for watching this video and hope you all gained a good knowledge about law of agency.